Good afternoon and welcome to our first Advisors Forum of the year as part of the Elville webinar series. Today's topic is Annual Estate Planning Update, a 2023 Fast Start, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's forum. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here, and thank you to our frequent attendees for being here as well. We welcome your questions, so please note your questions in the questions panel on your screen, and we'll take time throughout to address them. As always, your questions really add value and they help others learn, so don't be shy in posing your questions at any time. You also received the presentation yesterday by email from me to take notes on it if you wish. If you didn't receive the presentation, it's also marked in the handout section to download at this time as well. For our professionals here today, for CFPs, CPAs, and others, you may receive 1.5 continuing education hours for attending. And per my attendance records requirements that I have, if I do not have it already, please email me your ID number so I can submit your CE hours for approval and send out certificates tomorrow morning. Everyone will also receive a post-webinar feedback email right after the presentation, so please just take a few minutes to fill out this very brief survey to offer us your thoughts about today's presentation. So briefly, I'd like to offer you an overview about our firm and share just a bit about Steve before we get started, as I know we have several new attendees here today. So you should be able to see my screen actually after I click this button here. There we go. So Elville and Associates, we were founded in 2010 in Columbia by Stephen Elville. We have several different practice areas that we work on here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations, and Steve and I are coming to you live from the Columbia Gateway Community location today. Wish we were outside today. It's beautiful out. We have our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We focus on education a lot here at Elville and Associates, and we do that in several ways through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program, or CCP as we call it here. We're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. We also focus on the ideals of client education, collaboration, and compassion with every client every day here at Elville and Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning. A member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events throughout the year. Steve was also named to the Maryland Super Lawyers list for an 8th time and 7th consecutive year in 2023, so congratulations to Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am very privileged to be the executive director of. So if you'd like to learn how we make a musical difference in the lives of children each day, please reach out to me, and I'd be very happy to share our story with you when we have just a little bit more time. But for now, we're going to talk about an annual estate planning update. Steve has a lot of information to share, has worked diligently on a great discussion with you today. So I'm going to turn the presentation over to him.
Thank you, Jeff.
We'll clicking this button,
technology here.
We will do that.
Thank you very much, Jeff, for that. And I'm showing my screen and getting to the slideshow. So let's see if I can get there and start the slideshow. And here we are.
Great.
So thank you, Jeff, so much. And good afternoon, everyone. It's my extreme privilege to be with you once again in 2023 here in this early February. And thank you for taking your very valuable time on a busy day, on a busy Wednesday to be with us. And I'm going to go through a lot of information that I have gleaned from the recent Heckerling conference because of intellectual property rights and so forth. We cannot call this a Heckerling update, but it is a Heckerling update in the sense that I made various notes and personal interest points and copious notes when I was at the Heckerling conference. And I'm going to share those notes with you in the sense that these were the things that struck me as very important that for not only myself and all of the people here at Elville and Associates that do our practice and help us support our practice, but also as tools for you. And with that said, I want to thank Jeff Stauffer, my longtime colleague and friend, who without him, I couldn't put on these advisor forums and all of the other webinars and programs that we do. And we could not do it without your support either. So thank you. And I'm hoping that you get a lot of good continuing education out of this for those of you who are seeking the continuing education. But also, I also want to have you use this as a tool. Many Heckerling updates are out there, meaning the post-Heckerling conference meetings and summaries. There's much of that out there, and I know you have that available to you, as well as the Secure Act updates and all of those things that you already have access to. So I don't pretend to add more than that, but I hope to share things that I consider important with you that you can use as a tool in your own practice and helping your clients and yourself as you move forward. Lastly, I'd like to thank everybody here at Elville and Associates, without whom I could not do what I do. And I appreciate all of our attorneys and staff and you as well and your relationships with us. Okay, with that said, let's get into the discussion, and we're going to be efficient. We're going to cover, understanding the general scope of estate and tax planning concerns at the beginning of 2023, which is so fast, quickly moving forward here. We want to understand at least the fundamentals of the spousal marital deduction planning and 2022 updates, meaning any highlights from 2022. And I should stop again and just make sure everyone understands the information that is disseminated at the Heckerling conference is just overwhelming. And so there are many outlines, and many of the nation's greatest planners and tax planners and so forth and thinkers. So again, I don't pretend to be able to share all of that with you, but certainly the highlights that I felt that were important. Planning for wealthy families. This is going to come as no surprise to you, but what I will call in this presentation, the middle of the road rich. People that are substantially wealthy, we might call those people the new wealthy. It may or may not be applicable, but let's just call it that today. An overall view of elder law planning concerns in 2023, kind of going back and reiterating asset protection techniques, and an excellent presentation at Heckerling about that I wanted to give you the highlights of. Gaining a basic understanding of the Secure Act changes and how that affects estate planning. So much of the Secure 2.0 had nothing to do with estate planning per se, but we want to talk about the things that are fundamentally going to affect us in estate planning. And then understanding one of my favorite topics, which is why flexibility in estate planning matters, and why it matters even more today than ever, especially in certain types of planning. So let's talk about the current state of planning in the US for estate planning. Well, no surprise to many of you who are very educated about these matters, we have an unprecedented situation where we have $12,920,000 of inflation-adjusted estate tax exemption on the federal level. Never before seen anything like these numbers. Almost 26 million between a married couple, portability or not, with the ability to pass along all of that. And in Maryland, a $5 million estate tax exemption on the state level. So portability remains intact. I didn't hear a single thing at Heckerling about portability going away, or even anyone on the left such as folks like Bernie Sanders and others who want to kind of rein in the ability of wealthier clients to be able to take advantage of estate tax reduction and planning. No indication whatsoever that portability is going to go away. So this is an unprecedented time. No indication in sight that a reduction in the estate tax exemption, other than the scheduled reduction, remember, on January 1st, 2026, and even with that scheduled reduction back down to the levels of around 5.5 million, that is going to be inflation adjusted. So that will be a higher number than 5.5, even if that happens. The annual exclusion amount, if you didn't already know this, is $17,000 in 2023, and it's expected, although not guaranteed, to go up again next year because of inflation factors. Building flexibility into plans has never been easier. So not only am I a general fan of flexibility and having all of those options, that's a controversial thing actually, so I won't go too far with that. Many people are appalled actually that their estate plans could be changed because there's so much flexibility. So I will say flexibility is a good thing in my view, so long as there's client counseling and it makes sense for the client. But building these things in has never been easier. There are more estate planning options than ever. Again, I talked about the need for flexibility. Why? Well, economic, tax, political, you name it, lots of uncertainty in the world, including, the recent tragedies that are going on in the world. Our clients are fearful, and it's understandable. And I know you're on the front lines of that if you're a financial advisor on this webinar. And we understand that in the estate planning world that many times you are on the front lines of these concerns with clients, whether it's fear, whether it's elder abuse, whatever it may be. There are more favorable special needs planning options than ever before. So that's a very big thing. For example, Jeff and I often discuss the increasing rates of autism in this country, plus other disabilities. So this is a growing area. There's more certainty and not uncertainty. There's more certainty in elder law planning than ever before. Elder law planning could be summarized as a massive amount of ambiguity in the past. And as time goes by, one of the good things about the law and the way it's developing is that many things in elder law are more predictable for clients than ever before. So this is a great thing. So in my opinion, just from my perspective, the emphasis in planning must be twofold. We've got the legal technical, and then we have the practical. So we have greater tools than we've ever had before, but are those tools practical? Do our clients really understand the risks, let's say, of building in flexibility versus the risks of not having flexibility? It never ceases to amaze me. We can't seem to educate enough to make sure that our clients are informed, and I know many of you are committed to that same model. Now let's talk about, in the interest of time, and I hope you have a pen or a pencil or your computer up or your tablet up and you're making notes, or if you have a hard copy of this presentation in front of you that you're marking it up, so to speak. So I'm going to be going fast and furious through this. So using straight marital deduction planning is the correct approach for most couples. And for those of you who are not familiar with this, which most of you are, the marital deduction allows a married couple to pass along assets to the surviving spouse and thereby delay the calculation of estate tax, if there is any, or the liability for estate tax until the death of the surviving spouse. So I know many of you are familiar with this. So straight marital deduction planning, either outright distribution or distribution to what we call the marital share, and this could be in a marital Q-tip trust and so forth. All of these types of techniques continue to be the correct thing for the majority of couples. Let's think about this. We have $12,920,000 of exemption per person, and all a couple has to do is really leave everything to the survivor, either outright or in a marital trust, so to speak. And now the survivor can elect portability and exempt, at least right now, almost $26 million. I mean, it's very, very advantageous in most cases, but not all. So we want to think about using non-marital planning if it's appropriate. And there may be times when it's appropriate. So we don't want to be caught with kind of hitting the same nail or all the nails with the same hammer and not looking at each situation. So it could be that even though we're living in this unprecedented time, that there might be a reason not to leave everything by way of the marital share or the marital deduction and use a non-marital share plan. But before I get to that bullet point here, I don't want to forget to remind you that portability, the portability election, the ability of the surviving spouse to elect portability, now that that surviving spouse has up to 5 years to make this election. So this is a very big change. Nothing that happened just recently. It happened a few months ago, but this is just something I wanted to remind you of. So why would we think about not using the marital deduction, which is so easy and so simple because of portability? Well, there's no portability of the deceased spouse's generation skipping tax exemption. There's no portability. So that would have to be done by way of a reverse Q-tip election. So that's just one reason. Where the tax being deferred until the surviving spouse's death is not the best result when the numbers are crunched. So that's why I would encourage those of you with bigger estate clients, the clients that have assets of upwards of or more than 2 exemption amounts, to have a portability analysis done if you're not already doing that through your resources. So if you need that done, we have resources to be able to get that done. Where there are blended families, it may not be the best idea to leave everything to the surviving spouse in ways that would be contrary to multifamily or second or third or fourth marriage situations. There are statutory share issues where the new surviving spouse now has enhanced elective share ability. That is a new Maryland law as of October of 2020, but there are other laws like that across the country. The ported amount, where there's a survivor that elects portability, but that person remarries, and in certain scenarios where in the remarriage, the new spouse dies, well, now we have a possibility of losing the ported amount. So we don't want to be too focused on that. That's kind of hard for people to think about, that they could lose the ported amount. But it is true that technically speaking, after a remarriage, that the ported amount could be lost. If the new spouse has already used his or her exemption amount, okay? The deceased amount, the ported amount, the deceased spouse's unused exemption amount is not indexed for inflation. So, that is another reason to take a second or third look at this before we just all jump on the marital deduction bandwagon. And of course, there may be other beneficiaries other than a surviving spouse. So there's lots of reasons to think about this. I think probably if I'm ballparking percentages, probably 80% of couples the straight marital deduction planning is going to be the right thing, but we certainly want to look at it in each case. Let's continue. Reasons to think about the non-marital share planning. Well, portability, of course, requires the filing of an estate tax return, and this will increase the cost of administration. So that could be a reason not to do it. Now, I want to put these reasons in context. I want you to imagine that the speakers at Heckerling are arguably the greatest minds in estate planning for sure across the country. Many of these people are really challenged right now, and I'm just being very, very fundamental and down to earth here. Many of these people are being challenged because these are the greatest intellectual minds in the country, and they're used to lots of analysis. But see, with the straight marital deduction planning being correct for a vast majority of people, it simplifies planning. So what a lot of the material coming out of Heckerling is, well, yes, that's right, but what if? Because planning has been simplified for many people. So that's why some of these bullet points, I want you to know them as an intellectual thing, and we certainly do need to visit these issues. But for most people, the straight marital deduction planning is going to be the right thing. The portability election could affect certain beneficiary rights. So we have to be aware of that. It could depend on the type of assets that the deceased spouse has. So we have to look at that. And of course, if there's non-citizen spouses involved, there is no portability at all. All right, switching away from marital deduction planning versus non-marital, let's take a look at disclaimer planning. So this old fundamental way of dealing with estate tax planning was talked about. The disclaimer planning could be, in a minority of cases, the right way to go, where it gives the surviving spouse a second look. Now, let's be clear, even in marital deduction planning, a good estate plan is always going to have disclaimer provisions, okay? But there could be problems if we're purely relying on the disclaimer, and that is the willingness to disclaim. Many of these things are very fundamental that you've heard about for years. The timing of the disclaimer, if we're relying on disclaimers, the disclaimer has to be done within a certain period of time. And if someone has accepted the assets, they cannot disclaim them. Okay, so those are all reasons to either think that disclaimer planning is a good thing, but certainly I don't think in the majority of cases we're going to be relying on disclaimer planning, but it is a tool. And then of course there's planning and contemplation of marriage, prenuptial agreements, and we have to think through issues there in a big way because of the increasing wealth that our clients have. So let's talk about that increasing wealth. This is no news to you. Many of you read many more financial type articles than I have the ability to read. But let's talk about planning for wealthy families. So according to Forbes, and this is information from Heckerling, the top 1% of wealthy Americans now have at least $11 million. And I could be butchering that fact just a little bit, but I think that's what I gleaned from the conference. And many of our clients are now dealing with an average of somewhere between $22 and $50 million worth of net worth. These are what we would just simply call the middle of the road people who have wealth. And so these folks are going to have to continue to decide how to leave assets to their beneficiaries and whether those beneficiaries should be in control of their trusts or not. So that is a kind of an ambiguous sentence that simply, in my opinion, means when these wealthy families leave assets to their children, grandchildren, and others, they're going to have to decide, are they going to use independent trustees, interested trustees? The differences between those are big differences. There's going to be special fiduciaries like trust protectors that are going to need to be used. And I see this as just a continuing proliferation of bloodline trusts and trusts in perpetuity. So there's lots of decisions these types of families have to make. The grantor trust, the trust where the grantor pays the tax, whether it's a very simple grantor trust like a revocable trust, but in this context, grantor trusts on a broader scale, these continue to be the foundation of all advanced estate planning. And again, we want to go back to 2021 when the Biden administration first came into power, and Senator Sanders and others on the left and many powerful Democrats were arguing for the elimination of many of the grantor trust rules and a reduction in the estate tax exemptions and the inability for the continued and advantageous use of ILETs and many things that were very frightening. Those things did, as far as estate planning goes, those things came to a screeching halt, as you know, at the end of 2021. So the grantor trust is still remaining strong. We need to make sure client plans are very flexible and understandable enough. So imagine our wealthy families having come into this middle of the road area, if you can believe that, if we're correctly describing this kind of money. And it's overwhelming. They are concerned about two major things, according to the Heckerling speakers, and I agree. They're concerned about control and income. So our ability as an advisory team, so let's talk about this just for a second. Here at Elville and Associates, we, and I know I'm preaching to the choir here today, but we believe in the advisory team concept that our clients should have a team of advisors. So we as advisors need to understand just how difficult it is for clients to think about giving up control, even though we have these massive exemption amounts, even though we have all the flexibility of grantor trusts. And we have to understand that they need to understand enough that they would be willing to give up some control, but they may not be. So control and income. So the top techniques coming away from Heckerling are our wealthy clients need to understand the simple power of annual exclusion gifts, whether those are outright or given in trust. The use of the basic exclusion amount, $12,920,000, and being able to use that before it goes away. Hopefully it will not, but we know it very well may. GRATS, the Grantor Retained Annuity Trust, as not a home run strategy, but as a simple strategy to continue to extract assets from the taxable estate. And then life insurance as a wealth transfer tool, not because our wealthy families want to buy life insurance, but because this is a wealth transfer tool that I continue to be convinced that clients don't fully understand. And I think that for those of you who have the ability to convey these ideas to clients in ways that make sense to them, that is a very, very important thing and a very big talent on your part if you have that ability. We want to continue to remove highly appreciated assets from the estate. That's a given if we can do that. Remember that any time that a general power of appointment is utilized, there is a risk of exposure to creditors. So let's say that you have a client and that client is wealthy themselves or not, but they've been left a trust and they have a power over that trust, and that trust gives them a general power of appointment, the ability to basically appoint the property to anyone. Well, remember, it's one thing for that person to have that general power of appointment, which means the assets in that trust that they're the beneficiary of, those assets are now drawn into their taxable estate. So that's an issue. But this is another issue I'm talking about here. When and if they exercise that power, they are potentially exposing the assets into that trust to the claims of creditors. So we want to make sure if someone exercises a general power of appointment, that they are not subject to the claims of creditors at that time, because that could be a very bad thing. One of the things that the Heckerling presenters seem to be focused on was that there is a new Uniform Healthcare Decisions Act, which has nothing to do necessarily with the middle of the road rich, but it seemed to be something that the advanced estate planners were kind of coming down to earth and recognizing that this is important to clients. This tells us that no matter how wealthy or not wealthy our clients are, that the fundamentals never change. The advanced medical directive and all of the healthcare decisions still remain extremely important. And then lastly, even though I did not make it a bullet point here, remember that no matter how wealthy or not wealthy our clients are, arguably the most important document in the estate plan is the power of attorney document, the general durable power of attorney document that can provide so much flexibility and is so important given the fact that our clients are living so long. Jeff, I'm going to keep going until you tell me we may have a question, but otherwise we're just going to continue our CE here, our continuing education. So now I'm going to go into another dimension here, the asset protection update. This was an excellent presentation by an attorney, I believe, out of Texas. There are certain objectives of dynasty trusts, and of course there's many names for these trusts. Trusts that last in perpetuity, bloodline trusts, GST trusts. These are trusts that are simply in a silo, and it continues to go down the generations. So creditor protection, estate tax savings, and control. So in my prior example, where someone had received a trust, and that trust gave them a general power of appointment, well, probably, although every situation is different, probably there's no estate tax savings there, because just for those of you who are wondering what I'm talking about, when we have a couple or a single individual who are leaving money down the line, they're leaving money downstream, and they give their beneficiary a general power of appointment, well, Uncle Sam looks at the assets at the generational level of the person who died. And because there's a general power of appointment, Uncle Sam is now allowed to look at the second generation and decide whether or not there's taxation at that level as well. So generally speaking, in a dynasty trust, we are not providing for a general power of appointment unless it's a backdoor technique to avoid generation skipping tax, which is another subject. So that's what we're talking about here. Now, clients, as this speaker pointed out, may not care about perpetuity. So this is something that as the planning team, we need to understand. Not everybody is going to be concerned about that, but certainly a lot of people are, and they will take pride in that. Now, the prudent man rule has given way to the prudent investor rule. So we now, as a team, let's say that you're working with a trustee or you're working with an attorney who is acting as a trustee. Under the prudent investor rule, the trustee has a duty to diversify. And of course, trustees are reliant upon you as financial advisors to give us or provide us with an investment policy statement and assure us that we are walking the straight and narrow path as fiduciaries. But there is such a thing, as they brought up, as a purpose trust. And this is for concentrated assets. So there may be times when we can diverge away from, or go away from, I should say, the prudent investor rule in certain circumstances. But of course, being a trustee is full of risk, and all of this is subject to facts and circumstances. There are two types of asset protection trusts. There is the third-party type, and there's the self-settled type. So let's say that our clients are very wealthy. They want to go to an asset protection state, such as our friends in Delaware, and they say, let's do a self-settled trust. Well, Delaware allows for that. About 19 states allow for that. Nevada, Wyoming, Alaska, South Dakota, and we could go on, Nevada. So the issue here is that the self-settled trust, which you cannot do in Maryland and enjoy any kind of asset protection, but even in those domestic asset protection states, the self-settled trust is going to be suspect as to whether it really provides asset protection for the self-settled grantor. So the third-party trust, or what they call in those states hybrid domestic asset protection trust, these are going to provide the real asset protection. And I'm just giving you a very summary version of the asset protection trust types. And I don't pretend to be an authority on these other state laws, but I'm just giving you the update here that if your client wants to engage in this kind of planning, it has to be carefully thought out. We can't just make the blanket assumption that they will have asset protection in a self-settled trust. So the third-party asset protection trust is where we really want to be. Now, the third-party trust includes a spendthrift provision, meaning the beneficiary cannot give away the assets or assign the assets to a creditor. Of course, creditors cannot attach against this trust because it's a third-party trust. It's not actually settled by this person. It's not self-settled. Now, there are exception creditors. Exception creditors are creditors that can reach a trust no matter what kind of trust it is. And this is based on public policy. So alimony, child support, and obligations to Uncle Sam, these are exception creditors that can reach a trust like this, except in one state. And I apologize, there may be two. I can't recall the other one, but the main creditor exception creditor state is Nevada. So Nevada has no exception creditors, and they're very proud of that. Although I think for some people this is a bit distasteful, and even though you can do this kind of planning in Nevada, it may not be palatable because we're excluding alimony, we're excluding child support. But it could be that for a particular client, this is the jurisdiction that might need to be the jurisdiction of choice. So the speaker at Heckerling encourages us to think about that a discretionary trust is kind of the cake, and the spendthrift clause is the frosting. So if we want our clients to truly have asset protection and not just in name only, we have to make sure that the structure of the asset protection trust is sound. And we hear a lot of hype and a lot of noise about how much assets can be protected in certain states, but it cannot be a self-settled trust if we really want to enjoy great asset protection due to case law that has shown that self-settled trusts are not always effective. Massachusetts, as I've mentioned years ago in a webinar or an in-person presentation, is a state that has some case law that's very old, but it's suspect. And in one Massachusetts case, there was a spouse that was allowed to penetrate or be able to obtain assets of a trust that was left by a husband. He had put that, there was a trust, I should say, for him and for his benefit, but his divorcing spouse was allowed to get into that trust. So that case is an outlier case, but it's something to always keep in mind because many of our clients want to protect against divorce. So we want to include provisions, and of course we at Elville and Associates in recent years have always included these provisions, that a trust can be moved as far as its jurisdiction and state law. So here, when we start thinking about the differences in the various states for asset protection, now we start to see the utility just in this one area of being able to use a change of jurisdiction or change of state law to be able to move a trust if it needs to be moved, and that's an administrative duty. Let's go back to self-settled trust just once more. About 19 or 20 states have asset protection laws for self-settlement. This is not necessarily all it's cranked up to be, and we have to make sure that we understand that the third-party trust, again, is a better protective system. Now, some of you on this webinar may have heard of non-judicial settlement agreements. This is a fairly new creation in the law that allows an informal change of an irrevocable trust. And one of the big issues with non-judicial settlement agreements, which do not require the involvement of a court, is whether or not the people who were involved in the non-judicial settlement agreement are actually violating a material purpose of the trust. So non-judicial settlement agreements are so prolific, and they are such a nice way of, or maybe that's not the right descriptive word, they are such a convenient way of being able to change an otherwise irrevocable trust, that now the estate planning community is asking itself, what is a material change of purpose? And I think it's safe to say, and at least according to the speakers and in my experience, that no one really knows. No one really can define what is a material change of purpose in a trust. So the speaker is encouraging our clients to identify this in their documents. Of course, we always want to encourage clients to use letters of wishes or memorandums of intent as instruction to the trustee, informal instruction. But here we're talking probably about a provision in a trust saying such and such change would constitute a material a change of material purpose in the trust. So the estate planning community, I think, needs clarification. And I think that as a advisory team, we need to work with clients to understand their purposes, their goals, and understanding this flexibility that these days can be built in, this massive flexibility to be able to change trusts in the future. We need to make sure our clients understand that, and understand that if there was a change, what would really constitute a change in the material purpose that would violate the purpose of the trust. Okay, I'm going to skip down here to some states will strictly enforce a no contest clause. This seems to be a subject that comes up often at Heckerling. My experience has been that Maryland courts that I've seen will not strictly enforce a no contest clause where the beneficiary has a probable cause to contest. So this is something that is jurisdictional. And this one is interesting. Where there's a potential will contest, where there's a potential trust contest, pre-mortem validations, actions that are in court that would rule that a trust is valid is a preemptive thing that could be done. And so this is a very interesting area as well. Now, I won't spend a lot of time on this because we probably don't have a lot of attorneys on this call, but we might. But I think it's good for the advisory team to understand this, because many of you advisors are great referral sources and important referral sources to attorneys. And these relationships, when you refer, are very delicate, and attorneys need to understand that. But also, attorneys have to cease to engage with clients that are not good clients from the beginning. This doesn't necessarily mean your clients that you're referring, but this is just a good due diligence for all of us, that if we see something that doesn't look right or feel right or smell right, we probably shouldn't get involved with client engagements from the beginning. Now, from a lawyer's perspective, a lawyer does not have the unilateral right to terminate a representation, okay, except where the lawyer's continued representation of the client would violate the rules of professional conduct. So this is not going to be something that happens every day, but I think in light of all the presentations at Heckerling about international terrorism and money laundering, and I'm sure the rules and regulations in your own broker-dealers and industry, there's all kinds of ways that we could run into these situations together where certain clients are engaging in conduct that is not conducive with the law, and these are just good things to talk about. So where a lawyer can withdraw without material prejudice to the client and assist the client in getting a new lawyer, this is obviously the best way for the lawyer to go if you're involved in a situation like that. And of course, document everything. And then if a client on our end refuses to take a lawyer's advice, we must get them to acknowledge this in writing. Okay, I wanted to be very brief there. I didn't want to delve into that too much with most non-lawyers on this webinar. Jeff, I'm going to just check my time and take a sip of water. Any questions so far that I need to know about?
Thanks, Steve. No questions as of yet.
All right, very good. So let's continue our CE and our update. So the new Secure Act regulations are very, very favorable for special needs planning. So obviously the Secure Act is very detrimental to regular beneficiaries, people that are healthy and well. We know about the 10-year rule, and there are many iterations of that. But now for eligible designated beneficiaries, and here we're talking about disabled or chronically ill people, we know that the new regulations make things much more clear about who will be eligible as an eligible designated beneficiary and be able to stretch out their RMDs based on their life expectancy. Now, those who are chronically ill, this is a different definition in the code, they will be deemed eligible through a certification process, okay? But there are many people who are disabled, and this is something that was important, that was pointed out by the speakers, who are eligible designated beneficiaries, but they won't qualify based on these new regulations because they're either not getting SSI or SSDI, but they don't have a sufficient work record, and they stay at home, or they are minor children. So there is a problem that that has to be resolved. So one of the things that was pointed out was the ABLE qualification. So the Achieving a Better Life Experience account and the Maryland ABLE, for example, that the rules are more informal. They're more informal for ABLE, and it was suggested that a person who is eligible as an eligible designated beneficiary under the Secure Act should not have to go through such an onerous certification when folks who are beneficiaries of an ABLE account or owners of an ABLE account don't have to go through the same. So this is just an interesting observation, and it's something that we may see some change in this, that hopefully those people who are being excluded because of the onerous qualifications for as an eligible designated beneficiary, that those people will now someday have an easier track to become EDBs, eligible designated beneficiaries. And of course, if someone is an eligible designated beneficiary, documentation has to be provided to the plan administrator by October 31st of the year following death. So this is very familiar to you already. Remember that October 31st of the year following death is already the rule that's been around for years, where documentation has to be provided to the plan administrator by that time, as well as the other end of year dates, the September 30th date on the year after death, the year following the date of death, where beneficiaries have to be identified. Then October 31st of the year following death, like we said here, and then by 12/31 of the year following death, where the IRA has to be separated and established into various IRAs by that time. Now, just before Heckerling, at the end of 2022, there was a Consolidated Appropriations Act. And if you haven't heard this, this was very big. And this is where we really have the positive applications for special needs. So the contingent beneficiary of a special needs, or what I will call a supplemental needs trust, can now be a charity. So those of you who have clients with children with disabilities or other loved ones, and there is a special needs trust involved, you may or may not have known this, but the inclusion of a charity as an ultimate beneficiary in one of those trusts would destroy the ability of the beneficiary to be treated favorably for purposes of the required minimum distribution rules. And that was because Uncle Sam makes us look, prior to this act, makes us look downstream and all kinds of onerous hoops that had to be jumped through. Well, now this is a great thing for special needs families. And if you have such clients, this is something you can let them know about if you haven't already let them know. Many of those families have benefited from a charity, a charitable organization, or an organization that supported their child that they want to benefit at their deaths. After they've died and left assets to their child, after their child's death, many of these families want to leave assets to a charitable organization that helped their child. Now they can do that, and we don't have to worry about that. So that's a wonderful thing as far as I'm concerned. As of January 1st, if you go down to the next bullet point, January 1st, this is no longer a concern. So we need to notify all of our families. This does not apply to a donor advised fund. So we can't say, well, wow, you know, this charity thing is great, so we're just going to leave everything at our deaths to our donor advised fund, or a charitable donor advised fund that they don't own. That's just another one that they are leaving assets to. That will not work. That's a little nuance. So this can be left to the charity of their choice, but not a donor advised fund. Now, along these lines, for special needs planning, we have two types of trusts, and these are right out of the new rules. So I'm focusing now on the minutia of the Secure Act 2.0 and how it creates new nuances, most of them positive, for beneficiaries of special needs trusts. I want us to focus really on the Type 2 ambit, the Type 2 applicable multi-beneficiary trust. This is a fancy way of saying that this is our typical third-party supplemental needs trust. Now, for those of you who might get crossed up on this, remember we were talking about third-party trusts as opposed to self-settled asset protection trust. So a third-party trust is where a person leaves assets for the benefit of a third party straight to the third-party trust. That's what I was talking about. Well, in special needs planning, this is the normal routine planning, is there is a third-party trust established for the beneficiary. And because assets go from point A to point B, whether this is life insurance, retirement plans, or other assets from a will or trust, it goes straight into the third-party trust. The beneficiary's assets are preserved. And that's what we're really talking about here. When you see this type of terminology, the Type 2 ambit, that is a third-party supplemental needs trust. So this is the trust that we would normally use. Charitable organizations will now qualify as designated beneficiaries, just like I mentioned. But again, donor advised funds do not. So when you see this terminology, it's simply a third-party supplemental needs trust. IRA transfers to first-party trusts. Those of you who have clients with special needs children, they may have a first-party trust. And if you haven't heard about this recently, or you don't remember this, this is the trust that the state of Maryland and all other states will allow if the disabled person actually receives money themselves. They did not receive third-party money. They received money from an inheritance directly. They shouldn't have received it. they were injured at birth, or they were injured in a medical malpractice case, they were injured in a train accident. These people receive money, and that money is going to disqualify them from the public benefits they would be entitled to. So back to this bullet point says that if someone, a well-meaning relative, leaves an IRA to a disabled person, and that person is under age 65, that person can move that money into a D4A type first party trust. That's a mouthful. The D4A type first party trust, and that person can move that IRA into that trust with no taxation. So this could require a private letter ruling for that particular case, but there are a series of private letter rulings that actually allow this. And to my knowledge, this is the only time the IRS will allow an IRA to be moved as far as the ownership, not just a beneficiary designation, but the ownership of that IRA can be moved from from the beneficiary to the beneficiary's first party trust. And the first party trust is now the new owner without taxation. So that's something that you need to know about. That's been around for quite a while, but this is apparently a new PLR that they put out, and I haven't actually read it myself, but that is what they're talking about. It's advisable to provide for power to change beneficiaries in powers of attorney. Now, Elville and Associates and many of our colleagues have been doing this for quite a while. That is an advanced power. So this could be something very critical for your clients. It's a scary power. I remember as a young associate, the first time I saw this power, and it was rather uncontrolled in the document I was reviewing at the firm I was working at. But where we have a person who is the disabled adult, and that person, let me rephrase this because I don't want to get our disabled adults mixed up. Let's say that we have a very important beneficiary, like a special needs child. The parent has an IRA, or the person who is the plan participant has an IRA, but that person becomes disabled. And let's say there was some need to adjust the beneficiaries. Well, in a power of attorney, that power can be given to the agent for the plan participant so that the beneficiary designation can be appropriately changed if it is not correct. So this is the kind of flexibility. If that provision is written appropriately, that provision can be very effective without it being an uncontrolled and kind of scary power, which is really the power to change beneficiaries. So that is something that we provide in our documents with counseling to the client. But the 529 plans, it is now possible, you probably know this, it's now possible to transfer up to $35,000 from a 529 to the parent's own Roth IRA, where the child did not utilize the 529 for college. You probably are aware of that. In special needs planning, continuing here, we have to be careful about termination provisions, okay? We have to be careful about these. There cannot be a way where the special needs trust assets can be returned to the beneficiary. So across the country, we will see and review various special needs or supplemental needs trusts. And depending on where these were drafted, there can be these kinds of provisions. Well, these can violate the new Secure Act rules, and they can cause problems where it could disqualify the disabled or chronically ill person from life expectancy treatment. The ABLE account, many of you are familiar with this. The ABLE account now is going to be advantageously changed to say that a person can be disabled all the way up to age 46, not just prior to 26, but this will not be effective until the end of 2025. So the new age for disability for ABLE will now be 46 after January 1st, 2026. For now, we still have the age 26 limitation. And then there's a terminal illness exception. I'm not going to drag you through a lot of that, but these were kind of ancillary pieces of information. Trust tax rates are going to be taxed at higher rates than individuals. Those of you who are not familiar with the trust taxation rates or the mechanics of how trusts are taxed and how they should be managed, this is something that I would strongly encourage all of us on the planning team when we are working together for clients to really be talking to each other and get our minds around. Of course, many of our high earning beneficiaries are going to pay 37% no matter what, but the 37% rate starts at $14,450 of trust revenue, or trust income, I should say. And we know that through the concept of distributable net income, income is passed out to the beneficiary and it reduces the taxation of the trust or eliminates it altogether. And the beneficiary really will include that income on their own tax return, thereby in most cases reducing the tax. So we need to have our minds around this as we go forward. As trusts proliferate, wealth proliferates, this trust taxation issue is going to always remain. Long-term care exemption, so long as the policy qualifies, $2,500 can be withdrawn from an IRA and will not be subject to a 10% early withdrawal penalty. So these are just ancillary pieces of information that I picked up at Heckerling. Now, those of you who have been following our webinars or following state law know that as of October of 2022, just a few months ago, supported decision-making became the law. And we have written extensively about supported decision-making. We've presented extensively about it. And I found this very interesting because, and you may be experiencing this yourself in some way, but I have found that since the advent of supported decision-making in Maryland, many parents are mystified in some ways about using this concept and what it means for their children, for their disabled loved one. Many people are embracing this concept. We are talking about it in our conference room, and we are counseling people about the right of self-determination. But the speakers at Heckerling, many of them certified elder law attorneys, and some of them with special needs children of their own, feel that this concept is utopian in nature, and it's a beautiful idea, but it could be problematic. So the question remains whether supported decision-making will achieve its potential and its purpose. So, for example, as we go down to the next bullet point, one of the speakers who has a special needs child of her own, she elaborated that persons can appear compromised, of course, but they can be supported and interact with others. That's what the supported decision-making law is all about. But there are practical problems, okay? Who will be willing to do this, in her opinion, for free after the parents have passed away? And who other than the parents is really going to be willing to provide this support? So that's a rather skeptical view, I think, and I did not want to second guess or do not want to second guess her position on this because she's got a lot of experience in this area. But my experience is that there will be people who are willing to step up to the plate. It is kind of a situation where, in a nutshell, I would describe my current thoughts on supported decision-making. Many disabled people or chronically ill people will not understand supported decision-making, and it won't make a difference for them. Many people will partially understand it, and through their supporters and their loved ones, even under a guardianship, if you haven't read my article, this will make a huge difference in their lives, at least in theory, because their rights will be furthered well beyond anything that was recognized before. And then, of course, many disabled people and their loved ones will understand supported decision-making. And as advisors, we need to remember that supported decision-making can be memorialized in an agreement under Maryland law. And Elville and Associates has just perfected our agreement because the state of Maryland does not provide a form at this point. Some states do and some states don't. So we have to remember that it can be in writing, but interestingly, it can be just verbal. And it can be one supporter or it can be multiple supporters. So it's a very wide open, very ambiguous type of situation. And I think we just have to take it one day at a time, one case at a time, one set of facts and circumstances at a time. The FMAP benefits, meaning the extension of Medicaid benefits for any of you who have clients who have children, let's say, that are dependent, or families that are dependent on Medicaid benefits. Those are going to end as of April 1st, when the official end of the pandemic occurs. And so this is coming down the pike. These COVID-related extensions of benefits are going to end. Now, in supplemental needs trusts, ABLE provisions, the ability of a trustee to make distributions to an ABLE account, these can be included in a first-party trust or a third-party trust. Generally, we have always included them in a third-party trust, and it's important for us as an advisory team to know that that's a good provision to have in a supplemental needs trust. Robert Fleming, who is one of the nation's leading certified elder law attorneys and has been for years out of Arizona, he suggests that if we put these in first-party trusts, these are those regulated trusts that the state of Maryland has the right to scrutinize, that we might get some pushback from Medicaid, but he believes we should push the envelope and put those kind of provisions in there. ABLE continues to be a great workaround. Some of you are familiar with ABLE, and some of you may not be. From a planning point of view and from a practical point of view, ABLE allows flexibility. It is not always appropriate. For example, someone who is over 18, someone who is 23 or 24 years old with tremendous disabilities, or they have mental health issues, if their parent does not have guardianship, that person is going to be considered the owner of the ABLE account and would have access to all the funds. So this is a counseling issue. However, ABLE is a great way of giving a beneficiary independence. It makes parents happy. It has tax benefits. It's a great workaround in HUD situations where the beneficiary is living in HUD housing, but it's also a great way for the beneficiary to have more freedom, for example, to make personal purchases such as marijuana and other things that we wouldn't be normally thinking about on a day-to-day basis. Okay, so Fleming argues that even though ABLE has certain tax deferral benefits and there's a list of approved distributions, he argues that because the tax deferral benefits in reality, when it all comes down to it, are fairly limited, he argues that there's really no practical limit on the use of ABLE accounts, that when someone sets up an ABLE account, they can use it freely, even though they would be, upon audit, they would lose the tax deferral, as I'm mentioning here in the bottom bullet point, that he would encourage people, parents, family members, to think in terms of using ABLE for anything that is needed, regardless of the loss of tax benefits. Now, that's easy for Robert Fleming to say, but I think he's trying to make a point that the practical use of ABLE may outweigh the tax deferral benefits. As we know, there's no real reason to call a special needs trust a special needs or supplemental needs trust unless the family really wants to. So for privacy reasons, we can call it whatever we want. On the other hand, I've had many families that say, no, we want to identify this trust clearly as a special needs trust because we want there to be no doubt about what this trust is to be used for. So this is going to be a case-by-case thing. Where a supplemental needs trust, now this is always the third party kind, the kind where the beneficiary never receives any money, where that qualifies as a qualified disability trust, we can enjoy an extra deduction. So this is a great thing. It's something to not be missed. It's not going to be the end of the world if it's missed, but it's a nice deduction for the trust to be able to get. Remember that in irrevocable life insurance trusts, where there's a disabled beneficiary and there's supplemental needs provisions, we want to make sure that disabled person does not have a crummy right of withdrawal. So this is something that's being reminded to the estate planning community. And vehicle purchases, of course, the vehicle can be owned by the driver of that vehicle, such as a van for a disabled person, but the vehicle lien would be owned by the supplemental needs trust. Just to be clear, most vehicles, like a very expensive van, would probably be owned by the trust. That's what we're talking about here. Now, there are trusts, for those of you who are not familiar with this, there are hybrid supplemental needs trusts. What the speaker is really referring to here is not a third-party trust, and not a typical first-party trust, for example, like the D4A kind that I mentioned. But this is a first-party trust that can be used by someone who wants to transfer assets to a disabled beneficiary for their benefit. So let's say one of your clients is not well, God forbid, and they want to make a transfer to a relative who has special needs. So for example, a grandparent wants to transfer assets to a first party trust, or to a special needs trust, I should say, for the benefit of their grandchild who has a disability. Well, when that grandparent establishes that kind of trust, there is a very little known and not often used trust, and we're just going to call that a hybrid sole benefit trust, where that trust is for the sole benefit of that grandchild who is disabled, but the transfer of the money into that trust does not cause the loss of Medicaid benefits for the grandparent. So the grandparent can transfer that money into that trust in this particular situation only, and they will not have a Medicaid look-back period or a penalty period for having transferred those assets. Trustee selection in all trusts is one of the most important things happening in today's world. We present on that quite a bit here at Elville and Associates. Here, the speakers are talking about, they recommend, and I think this is a very interesting thing, they recommend the use of third-party trustees, such as banks, independent trustees that are individuals, trust companies, and their argument is, why have family members as trustees? They're not probably qualified to do it. They may not want to do it, and they may be much better at being advocates for the disabled loved one and not in the role of managing the money and doing things where they've never had experience doing this. So I thought this was really a compelling argument, and that family members can be much more effective if they're not serving as trustees. But all of this, of course, is situational according to our clients. Accountings, we know that a trustee should be accountable, and trustees could, through a trust protector, be compelled to account. But the point here is we want to make sure trustees are accounting at least every 5 years or so and getting that approved by someone. It could be a trust protector, it could be a court, just to make sure the trustee is limiting their liability and being transparent. And I know we've been going quite a while now, so let me continue and we'll wrap up soon. The Gallardo versus Marstiller case, this stands for the proposition that when someone, this is a recent case, by the way, unfortunately, when someone receives a settlement, of course, there could be a Medicare set aside. There could be fees that are recoverable by the state and federal government. This state, unfortunately, says that not only can those fees be recovered, but also for projected future expenses. Normally in the past, a person would receive a settlement and the Medicare set aside would be made, and that would be it. That was the amount. But now this new case appears to stand for the proposition that the person's expenses up until the time of the settlement and a projected future amount of expenses can be recovered in advance, thereby lessening the amount of the person's settlement. So this is not a happy result, but we need to be aware that this can happen, and many of you have seen these types of Medicare set-asides. As we head back to planning for the middle rich, powers of attorney should be broad, so I'm switching gears on you now, back from supplemental needs planning or special needs planning back to the middle rich, and we don't want to have those powers in conflict with the revocable trust. Elville and Associates has always made our powers, the power in the powers of attorney and the power articulated in the revocable trust, as parallel and equal powers. So this is not anything new to us, but this is a good way of thinking about how powers should be structured in documents. We talked about the Uniform Healthcare Decision Act. That's supposed to be finalized soon. This could be a big thing. Maryland advanced medical directives have not been updated as far as the form goes. They have not been updated in many years. I would say at least 12 to 13 years. So this could affect us, and we'll keep you informed. Test trusts. Test trusts can be used to give children kind of an experience to see how they will handle their trusts. So this is something that we've seen in our practice recently. Wealthier clients saying, I want to see if my kids can handle things. I want them to handle things. Let's set up a test trust. So that's something that we are seeing and dealing with. So that's something your clients can do. Spousal lifetime access trusts, SLATs. Many of you have heard of this. Many of you are seeing many of your clients do this over the past 3 or 4 years. In reality, these are just these are just lifetime bypass trusts. So what is a bypass trust? It's a non-marital trust. All this is a lifetime non-marital trust. If one spouse is creating a SLAT, and we've seen this, folks that have maybe a $20 million net worth, so they're not going to do 2 SLATs, they're going to do one, and they're going to fund 12 or 13 million into one SLAT, so to speak. We want to make sure that we partition off other assets, because if that other spouse is not giving we don't want to say reciprocal, so we want to say a non-reciprocal SLAT to the other. The biggest worry here is that one spouse is making this irrevocable gift into an irrevocable trust, and then the other spouse is not reciprocating. So if we do that, we have to be very careful because of concerns about divorce and so forth. Upstream planning. This is something that's mentioned every so often at Heckerling, meaning if we have less wealthy relatives up the line, these relatives can be given assets at death. This is a strange concept, and they can be given a general power of appointment. And we just talked about, well, maybe that's not such a great idea. But what this does is it can use unused exemption amount of upstream relatives. Of course, this is very full of risk, and we have to be very careful. Exposure to creditors, all kinds of things here, which I will not delve into in the interest of time. Retirement plan assets. Of course, clients want options. There are not many options, but clients want options. The new required minimum distribution age is 73. I won't spend a lot of time on QLACs. I'm going to leave that up to you, financial advisors and CPAs. For employees of nonprofits, they can roll their IRA back into the company qualified plan and not have to take RMDs. Roth conversions, here's some information about that. And of course, qualified charitable distributions are still allowed. Beneficiary designations, outright distributions to spouse is still arguably the best option, okay? Charities, we want to make sure when we leave retirement plan plans to them that we use a custom beneficiary designation. We don't want to run IRAs through a revocable trust. Those of you who may have heard me speak before or dealt with Elville and Associates know that I'm not a big fan of doing this from the beginning, because when we have a revocable trust as the conduit, so to speak, of an IRA, there are ways that that could blow up. In some circumstances, that's the right thing to do. Disclaimer provisions and beneficiary designations to a donor advice fund might be a good idea. And then, of course, we always have to plan where we have blended families. We have to really take 2 or 3, 4 different looks at how we're going to structure planning. Now, in the interest of time, because I know we're getting short on time, qualified terminal interest property trusts, or what I would call that marital trust. If an IRA goes to the Q-tip trust, we have to be very careful, okay? It might be better in second marriage situations not to do that and to kind of split the assets outright between the children and so forth. Again, we talked about grantor retained annuity trusts as being a low risk option. Qualified personal residence trusts, we are now living in a favorable environment for that. And back to donor advice funds again, the consensus at Heckerling is with a donor advice fund, there is now little reason to establish a private foundation. This was the general consensus. So I won't, in the interest of time, go over this particular slide. The Florida law updates are amazing for those of you who have Florida property. For those of you who have Florida clients, I'm just going to emphasize that Florida's laws are very, very different from Maryland law. Florida is a very unique place, and when your clients are doing planning in Florida, or if you have Maryland clients that have property in Florida, and there's a lot of contact with both states, the differences in the laws and the way that the laws are constructed in Florida, I strongly recommend that you use Florida counsel and make sure that your Maryland counsel who's dealing with a Florida client is co-counseling at least with Florida counsel. Decanting, the changing of one trust into a second trust. Maryland is right now, as we speak, I probably received 2 or 3 emails today about this already, and I'm going to be on a phone call tomorrow about this with the states and trusts. Decanting is a bill that's now before the Maryland legislature to bring Maryland up to speed with some other states, such as our neighbors in Delaware, our neighbors in Virginia, allowing a trust to be changed from one form to a second form. So this is something that we talked about early on, flexibility and how far is too much. And so we want to limit the scope of decanting because it can actually violate the settler's intentions. So decanting, according to the Heckerling presenters, should be considered a last resort. And when you think about it, is the antithesis of what a grantor might want at the time of execution. So with that said, we want to kind of bifurcate this and give clients the best of all worlds, as long as they understand the pros and cons of decanting and flexibility into the future. We talked about non-judicial settlement agreements, so I'm not going to go through that again. So Secure Point 2.0, as we start to wrap up, planning for retirement benefits. As I mentioned, most of the laws are of minimal effect on estate planning. However, the new RMD age is 73. The IRS now recognizes a see-through trust. So remember when that IRA was left through a revocable trust? That revocable trust must be a see-through trust. It must meet the requirements of a see-through trust, and that IRA will actually go through the revocable trust as if the revocable trust did not exist. Conduit trusts, we know that that is a trust where any distribution from an IRA must be immediately distributed. Accumulation trust, we know that is a trust such as a supplemental needs trust, where a distribution from an IRA goes into that trust, but it can be accumulated inside of that trust. And we know there are tax concerns with accumulation trust, even though with supplemental needs planning, we have to make those trusts accumulation trusts. So the IRS, is recognizing these terms for the first time. So when I started this presentation by saying we've got a great environment for clarification and the laws seem to be favorable across the board, these are the kinds of things that are happening. So we've got to remember that when a retirement plan is paid to someone who is a designated beneficiary, okay, we are going to be in pretty good shape. But a trust is not a human. And so that's why it has to pass the see-through trust rules, okay? And so we just want to reiterate that to you. Now, Natalie Choate, who is the nation's #1 authority other than Ed Schlott and maybe others on estate planning for retirement plan benefits, she was basically going through the motions, which are beyond the scope of today's discussion, but talking about how we now can look at the simplified rules about making sure we're not shooting ourselves in the foot when we are structuring beneficiaries and where a trust will be the beneficiary of a retirement plan. So we have to make a list of all beneficiaries. We have to divide them into 2 tiers. We have to make final determinations. We have to figure out who the countable and non-countable beneficiaries are, divide by an applicable denominator. We have to go through these things, but even though it's still complex, it is simplified compared to what it was before the recent Secure 2.0. And of course, as we go through that analysis, we have to figure out what is the applicable payout. Now, there are charts. Ms. Choate provided charts, which I'm not allowed to share with you, but I will just say we have these payouts that we have to be concerned about. Most of you are familiar with it. Payouts to an individual. Did the plan participant die before the required beginning date? Second payout to an individual. The plan participant died after their required beginning date. So there's going to be 2 different results there. And then when the payout is to a trust, did the plan participant die before their required beginning date? And again, payout to a trust, did the plan participant die after their beginning date? So there are some wonderful trusts. I'd be happy to meet with you there are some wonderful charts is what I meant to say that simplify this, and I'd be glad to meet with any of you, counsel with any of you about these things. I know you have your own resources, but these are very fundamental things that I thought it important to share with you today. Charitable contributions, we talked about that. Many of you are very familiar with this, qualified charitable distributions. Trusts can be reformed post-mortem. This is something that could become a problem. Let's say someone passes away, there are problems. The trust could be reformed as long as it's done prior to September 30th of the year following death. So there are generous post-death changes. So again, these estate tax change, state law, state planning changes are limited, but some of them are very powerful. And of course, we have those critical dates, as I mentioned earlier, September 30th of the year following death. That is the date beneficiaries become final. That has not changed. Documentation has to be presented to the plan administrator by October 31st of the year following death, and then the December 31st breaking out of the IRAs into separate IRAs and finalizing the IRAs by that time. Most of you are familiar with that. If an IRA is designated to a revocable trust, remember we're talking about running that IRA through a trust or not, meaning a revocable trust, there is no life expectancy treatment. This is nothing new. So we many times are going to look at the subtrusts for the beneficiaries, the subtrusts that are created under a revocable trust, and we're going to designate the IRA directly to those subtrusts. So we are going to have a much more efficient disposition in most cases. There is an exception that is very favorable. Where there is a disabled or chronically ill beneficiary, the IRS will test separately for the life expectancy treatment. So let's say an estate planner and a client ran the plan participant ran the IRA through the revocable trust, but there was a disabled beneficiary that was a beneficiary of that revocable trust. The IRS will allow separate life expectancy treatment for that beneficiary. And then at Heckerling, they revealed that this nice lady, Denise Appleby, has a free secure 2.0 chart if you would like to download that. And of course, the Limeberg newsletter is always a tremendous resource, even though sadly, Steve Limeberg, who was legendary for his newsletter and his expertise, recently died. So I think that is it, Jeff, and I'm going to thank everybody for their time and attention. I went a little bit longer than the hour and 15 minutes I thought we would have, but I will be here if there's any questions by email or other contact. And we want to be a resource to you, and we hope that this CLE or this continuing education for you was valuable today. Take this for whatever you may be able to use, the nuggets of substance. That's something that may be triggered in your practice that you'll be on top of now, because this is more top of mind. Jeff, I'm going to turn it back to you.
Okay, well, thank you, Steve. And now would certainly be your time if you have a question for Steve to get that question into me so I can relay that over to him. And certainly like to thank Steve for a real comprehensive presentation. A lot of time and effort put into that for our benefits. So thank you very much, Steve, as always. And also want to thank you, our attendees, for your interest in our advisors forum and part of our Elville webinar series that we have here. I'd like to thank you for your relationship with our firm as well. If it's been a while since we've met, or we have never met at all, let's find some time to get together to learn how we can work together and learn how we can best serve clients together. Love to reach out to everybody that's been on this presentation and get that on the calendar. So I'll be doing that for everybody here soon. Also, for our webinar series, if you are interested in more continuing education, most all of our webinars do offer continuing education hours, either 1 or 1.5 hours more often than not. So consider joining us if you haven't done so in the past. Last thing I'll say is on February 17th, we have our estate planning elder law essentials coming up. That's going to be with Steve. On February 22nd, we have a new topic, cryptocurrency, gaining an understanding and making informed choices. That should be intriguing. And then on February 23rd, we have Medicaid long-term care asset protection planning with our senior principal here at the firm, Lindsay Moth. So some varied topics for you to choose from, all with continuing education for your benefit. So again, we appreciate you being here today. Hope you got a lot out of today's presentation. Doesn't look like we have any questions, Steve, so I think we'll call it a day and a success. So thank you, Steve, and thank you to everybody for being here today.
Thank you.